Hi friends, and welcome to the first class of Tort. This is Lokesh Pathak with you. Tort is a subject which has came from English law and law of England. It is taken up from there. So you must know that there is no definite statute or law related to law of tort. It's just based on maxims and case laws. So this is a bit strange subject because here you will not find any statute or sections or article like Constitution of India. You will be knowing the things with the help of previous cases and the maxims of from English law, and based on that you will be learning the subject. So the first thing which we are going to learn today is what is tort, the word meaning of tort, how it came from and from where it had came, and then how it has been interpreted in the practical application. So if we see what tort is, the word tort is actually derived from a Latin word which is tortum, and it has three meanings. One is twisted, something which is twisted, which is not straight. Crooked, something which has crooked component in it, and illegal. So if somebody asks you what is tort, you can say tort, the word meaning of tort is twisted, crooked, or illegal. In English, the word meaning of tort is wrong or equivalent to wrong. So if something is crooked, illegal, wrong, or twisted, it is called tort. The word tort has came from the writ of trespass from English law. So we must know what does trespass means to understand that if it is based on the writ of trespass. Trespass is entry without consent, and that entry could be on the premises owned by somebody or even on the body of somebody without his consent. So any entry without consent on premises or body related to some person or some owner, that is called trespass. So tort is based on this writ of trespass. The standard definition of tort is that tort means a civil wrong. Although in Indian jurisdiction or Indian law's perspective, this definition can be extended to some extent. Like the Limitation Act 1963, the section 2M of Limitation Act, it defines the tort. It says that tort means a civil wrong which is not exclusively a breach of contract or breach of trust. So it does not limit the application of tort to the law of contract. It says that it is not exclusively. It means it may or may not be related to the breach of contract or breach of trust. But ideally it is independent of your contractual obligations. Means if there are two parties and they have agreed to a contract, so when we discuss about the contract or obligations as per the contract will follow. But when it comes to tort, it becomes law in general. So any liability in general, not specific to the contract, but in general towards the society, towards the public, towards the people in general. So that is covered under tort. So this definition is clear enough from the Limitation Act that tort means a civil wrong which is not exclusively a breach of contract or breach of trust. Now Salmon extrapolated this definition. Salmon divided that into four parts. The definition as per Salmon is a civil wrong, first, for which remedy is common law action, means that will be redressable with a common law action. Second, for unliquidated damages. So it is clear that in tort, the damages which are claimed for compensation, they are unliquidated. Unliquidated means they are not fixed. So in contract, you have seen that there are some liquidated damages, which are penalties which are already fixed. But in tort, it's not fixed. It depends on the injury you created as per the like not as per the contract, but as per the law in general. So these 2 points are very important in Salmon's interpretation, and the other two are what he has taken, which is similar to mentioned in the Limitation Act, which is it is not an exclusive breach of contract, and the fourth one is it's not an exclusive breach of trust or other merely equitable obligations. So if we combine all these four components, the Salmon definition becomes a tort is a civil wrong, first, for which remedy is a common law action, second, for liquidated damages, and third, which is not exclusively the breach of contract, or fourth, breach of a trust or other merely equitable obligation. So this is the definition from Salmon, which is a quite elaborative because it talks about the unliquidated damages as well as the nature of the remedies, which is common law action. Now coming to tortious liability, what it is and how it is being defined. So Winfield defined the tortious liability as a breach of duty which is primarily fixed by law. So it's not specifically a consequence of a contract, but it is a duty which is primarily fixed by law. So any breach of that duty is a tortious liability. And this duty is towards persons in general. And this breach is redressable by an action for unliquidated damages. So Winfield's interpretation for tortious liability is that tortious liability arises when there is a breach of duty primarily fixed by law, and the further elaboration is that such duty is towards people in general, and this breach is redressable by a action for unliquidated damages. So beyond these definitions, we have seen that the nature of remedies in tort action is uncodified. So torts relates to uncodified because there is no specific statute which it follows. The compensation, or basically the injury which is occurred, and the previous case laws and the existing maxims, this all collectively decides the nature and scope of the compensation. So that's very clear that it is an uncodified sort of law. So that is why it is based on maxims and case laws only, and there is no act or statute involved. Now the nature of this is unliquidated, means it is not fixed, it is a variable sort of compensation. And now, not the last but not the least point is what are the principles of common law, because this all maxims and case law from where it has came, because there is no statute. So the basis of the remedies in tort action is the common law principles, and these principles are equity, justice, good faith, and inner conscience. So based on these four common law principles, tort works. I am repeating these: equity, justice, good faith, and inner conscience. So we have seen in this what is tort, the definition of tort, the tortious liability, the definition, Salmon interpretation, and Winfield's interpretation. We have seen that tort, the word meaning of tort, we have seen that it is twisted, crooked, illegal, or wrong. It has came from the writ of trespass. And then we have seen that the nature of tort is it is uncodified law, and it has the nature of compensation in it is unliquidated damages. So this is all we have seen as a basic concept of tort, which is very necessary to know before you start going into details of the subject. So this is all for this class, and in the next class we will be discussing about the elements of tortious liability. So tortious liability, we will see what are the mental elements as well as the general elements. Take care. Bye.